Hi, CCAR colleagues. My name is Matt DeFanis, and I'm going to hang out with you for a little while to talk about updates to the Champaign County Association of Realtors residential sales contract. Now, many of you have met me because I've done your contract orientation if you're relatively new in the business or you've worked with me on a transaction. But the reason that I get to spend time with you, well, there's a few of them. One of them is I'm the biggest nerd, and so I've got this Zoom studio, so I'm well equipped to do training videos like that. So honestly, that's a big part of why I'm the one that's doing this. But also, I am a past president of the Champaign County Association of Realtors. I have the benefit of a law school education. I'm a boots-on-the-ground practitioner, a multi-office broker owner, and I have also served on the contract working group for like 20 plus years at CCAR. So that's why I'm the one that gets to do this, and it is an honor to be able to spend some time with you. So we are here to talk about a new update to the residential sales contract, and this is nowhere near as big an update as the one that we had a year ago. I would characterize this much more as a cleanup version of the contract. Basically, even when you get lawyers, but especially when you get a whole bunch of lawyers involved in a process and then turn it loose in the marketplace, there's bound to be unintended consequences. And that just is a fact of life. That's not intended to disparage the attorneys or the realtors that toiled over this. But the reality is we've learned in the marketplace, we had several things that were frequently occurring, areas of misunderstanding or pinch points or misuse. And so that's what this is. This is much more an effort to clean up and clarify. It's not anything that's major. So we're going to run through these item by item. I'm going to reference line numbers in the new version. I'll tell you what it is. If there's specific technical verbiage, I may read it to you and show it to you word for word on the screen. And then if there's an explanation, I'll go through that. So we're going to start and just go right in order. So line 32, you're going to find that the home warranty provision has just been moved. And the only reason that we did this is it just makes more sense. We've moved it for layout and thematic purposes. And by thematic, what I mean is in the paragraph where the purchase price is and other typical concessions that cost a seller money, like closing costs, we're adding this there because it's very much like that. As far as the seller is concerned, it's identical to closing costs. It's some additional amount of money that's being debited from the seller's proceeds. So you'll find that now on line 32, the home warranty provision. This next one is a fairly significant one. Lines 54 through 60 provide for exclusion of items disclosed on a pre-listing inspection. We previously had no mechanism for excluding from paragraphs 5A2 and 5D items that were shared from a seller's pre-listing inspection. If this gets filled in other words, if you put in the company that did the inspection and the date of the report, it means that all pre-listing inspection conditions are accepted as is unless, and this is a big unless a separate repair amendment is used to indicate that the parties have agreed otherwise. So here's why this change came about. The home inspection contingency was binary. You either had one or you didn't. And during the really hot market period, we had an awful lot of sellers and listing agents who would do pre-listing home inspections with the hope that you would get a buyer to completely waive the inspection contingency. But that caused problems if you had a buyer who said, well, there was no radon testing, I want to test for radon, or there was no mold testing or some other specialized type of test, I want to test for this particular item, and you were either, or even just termites, you were either all in or all out because paragraph 5D, the home inspection contingency, was binary. It was either on or it was off. And so in this case, you can have a contract with an inspection contingency while still giving the seller the benefit of knowing that the items that the seller has already disclosed are now off limits. Now, you may have a seller who discloses those items and the buyer says, no, I'll accept many of these things, the common concrete cracking, fine, whatever. But there's a couple items in here that are a big deal that I do want done. I don't want these waived. Well, then at that point, the buyer can still put those items in a repair amendment. So hopefully that makes sense. If you list a pre-listing inspection, the default setting is everything that's in there is being accepted as is by the buyer. If that's not the buyer's intention, the buyer needs to put on a repair amendment with the offer what items the buyer wants repaired. And then finally, and this is something I talk about in our regular contract orientation, it's a little counterintuitive, but let's say that you have a pre-listing inspection, the seller's written notes saying these things have been repaired, but it's the seller who's written notes in the margin saying these things have been repaired. That does not a binding repair obligation make, because a different part of our contract says if it's not in the pages of the contract, it's not part of the deal. So the counterintuitive part is you may have a seller who has represented, I've already done these items. And even in those cases, if you can't verify that the items have in fact been done, or you don't have invoices showing they were done by professionals, you may still want to use a repair amendment as part of your offer for the exact items the seller says the seller's already repaired. And the reason for doing that is that repair amendment is the only way we have to ensure an enforceable obligation that the seller has done those items and done them in a reasonable and workmanlike manner. So hopefully that makes sense. But the bottom line here, the improvement here is if the sellers have a pre-listing inspection, they get a bunch of benefit from that, and it doesn't force the buyer to turn the inspection contingency all the way off. We now have some additional options. Final walkthrough. This adds detail in lines 64 through 66 as to the purpose and the limitations of the final walkthrough. So this new verbiage says it is to confirm that all items warranted in paragraph 5A2 are in operating condition, that all repairs agreed to pursuant to paragraph 5D have been completed, and that the premises have not been destroyed or materially damaged under paragraph 9. In other words, it gives a limited scope. You cannot come through and do all sorts of other things or do anything destructive. It just adds a little bit of clarity to what the purpose of that final walkthrough is. Next up, we have several inspection contingency cleanup items. So we're going to start with line 83. This adds an initial line to allow for a limited specific type of inspection with a blank to indicate the details of the scope of that inspection, such as, for example, a mold inspection. So as I said earlier, the 5D inspection contingency under our outgoing contract is binary. Either the whole inspection contingency is activated or the whole thing is deactivated, and there's really no in between. This allows for a mechanism to be able to assure sellers all these other things are off limits. We're not doing any of these things to you, but we do want to check on this particular item. Either we want to get a roofer out because there was a recent storm, or your pre-listing inspection indicated that there may be an issue with fill in the blank. So it allows for a more specific surgical nature of we want only this type of inspection. Everything else is off limits. Lines 85 and 86 clarify that if there's no date filled in on the notice deadline, it means the inspection contingency has been waived. We had a few people who were creatively interpreting the contract before to indicate that a blank notice deadline did not constitute waiving the inspection contingency and that it just meant the buyers could take as much time as they wanted. So now we're clarifying if you don't fill in a date, you've waived your inspection contingency. As always, it's a good practice to put in N-A not applicable or waived, just so you've done something with proof positive that that was the intention of the parties. Next inspection contingency cleanup item can be found on line 87. This clarifies that a post-inspection notice must consist of demands to remedy any qualifying deficiencies. Not a big deal. That's kind of a technical change. And then next is on line 89. That clarifies that the only form to be used for serving a notice under this paragraph is the current approved version of the CCAR Notice of Deficiencies and Post-Inspection Amendment. This change came out of the fact that somebody pulled a previous version of the CCAR post-inspection notice, the old version that had a termination, unilateral right of termination, even though the contract that we use now does not have that right, and checked that box and said, hey, I've terminated the contract. So this clarifies you can't play Mr. Potato Head with old versions of our forms. You have to use the current version of the CCAR Notice of Deficiencies and Post-Inspection Amendment. Next on the inspection contingency cleanup list is lines 118 to 125. This provides better clarity for how post-inspection negotiations must end. Now, just a quick refresher. The current version of our contract, the one that we're replacing and the one we're going into, has a notice deadline, and then there's a 5 business days period by which the sellers have to respond. And once the sellers have responded and say, here's what we're proposing to do, the buyers have 3 additional business days to elect whether to proceed or not. The problem is if they didn't come to an agreement, it left a little bit of a lack of clarity. And so now we have a very specific way that this will end one way or another. So the buyer either notifies the seller that the buyer has elected either to proceed with the transaction or to declare the contract null and void, meaning seller said, here's what I'll do. Buyer says, I will take it or I will leave it. And if I leave it, I'm walking away and I get my earnest money back. But if the buyer doesn't, if the buyer fails to respond by that agreement deadline, the contract will continue in full force, and the sellers will be obligated to make the repairs and or provide the credit that they have offered. In other words, you can't end up with a technicality where the parties get past that deadline and we're trying to decide, do we have a contract or do we not, or has the contract technically terminated on its own, even if that wasn't necessarily the intent of the parties. Or the sellers have said, no, you asked for stuff that was out of bounds. We agreed we'd fix the stuff that was within bounds for you to ask for, and you never responded. And so what this will do is it will ensure that the sellers, if they make some sort of a good faith offer as to what they'll do in response to a post-inspection notice, they will be bound by that offer. If we blow through this deadline and nobody says anything, the sellers will be bound by what they offered the buyers in response to the buyer's original post-inspection agreement, and the buyers are still obligated to this contract. Both parties are still obligated to this contract. So again, the point of this is to ensure a slightly better predictability to how the post-inspection negotiations end, instead of having them either sort of fizzle or leave the parties uncertain as to whether we're still under contract or we are not. We have radon changes under the inspection contingency cleanup. You can find those in lines 128 to 132. We've taken out what we ultimately realized were unnecessary duplicative options, where it was buyer will pay, seller will pay, or the parties will, we'll just put in the parties will split it. And if we want the buyers to pay, we'll put that the buyer pays 100%. So we've just streamlined that. So you have just one option, but it is a fill in the blank option. Now, I went to law school to avoid math, but we're trusting all of you to make sure that the two blanks added together do equal 100%. Also, if you leave those blank, the buyers are waiving the right to radon testing. Now, this is also a big deal because remember, going back to the previous issue of the inspection contingency being binary, you either had the whole thing or you had none at all. In this case, we're able to do this a little bit more piecemeal. You can have a notice deadline in paragraph 5D. You can be reserving for yourself a home inspection contingency, but by leaving blank this section that's specific to radon, the buyers are waiving the right to radon testing. In the previous version, if nobody checked a box, it was not totally clear what was happening, or if the buyer was still going to test, but simply not agreeing up front what we were going to do if it tested high. Now it offers additional options for leave it blank, and we're promising in writing we don't even reserve the right to test for radon, much less hit you up for it. Hopefully that helps. It also adds a requirement that radon remediation has to occur at least 3 days prior to closing. We've run into issues where either you want to do retesting and we don't have enough time to retest without delaying closing. We've also run into issues where occasionally we'll have a lender who may end up with a delay if the radon mitigation system isn't installed until the very, very, very last minute. So now we have a 3-day advanced or 3-day ahead of closing requirement. We have moved around the items accepted as is, basically the carve-outs of things that we're saying up front we're not going to ask for in the inspection contingency. You can now find those in lines 153 through 155. Again, that's really just a formatting change. Our next and final major set of additions are financing contingency additions. So let me give you a little bit of background on this. We have always had a cash without contingency and cash with contingency option in the financing contingency section. And the idea was cash, no contingency is I have the cash. I know I have the cash. It's sitting in my money market account or sitting in my checking account or sitting in my Brinks truck. It's parked in the driveway, any of those things. But I know I have the cash and it's accessible to me right now. That would be the sort of scenario whereby the buyer would do cash with no cash sale contingency. I've got the cash, period. Cash with contingency would be, I intend to get the cash. In other words, I'm not going to get a mortgage secured by this property, but that money is coming from somewhere else and I don't have it yet. So I have a cash sale with a contingency to get my hands on the money or to confirm I will be able to get my hands on the money, whether that's borrowing against a retirement account, borrowing it against some other property, accessing some other type of line of credit, whatever. So cash with contingency was, I plan to pay cash, that is to say no mortgage secured by this property, but I don't have it in my hands yet and I need X number of days to ensure that I can get it. What this adds is a cash sale transaction where a buyer plans to obtain a mortgage secured by this property, but they're promising in writing that they're not going to walk away if they have any issue getting it. Here's why we needed this. we would have, especially in the hot market conditions, buyers falling all over themselves to sweeten the deal. All right, I'll remove all contingencies. I'll make it a cash sale, but I still want to get a mortgage. I'm saying in writing it's a cash sale, meaning I can't walk away if I run into mortgage problems, but I do want to get a mortgage if I can. Well, the problem with that is there was no right to access the property for an appraisal. There was no obligation on the part of the seller to cooperate with the buyer obtaining a mortgage. So that's what we're looking at now. So that was sort of a long background way of explaining why we're here. So now if you look at line 287, that's cash transaction, no mortgage. You do still have that same cash sale contingency option. The new part is 290 to 294, lines 290 to 294. Cash transaction, mortgage allowed. It's not contingent on a mortgage, it's allowed. It ensures the seller will cooperate and not block efforts by the buyer to obtain a mortgage. The buyer promises to close regardless of being able to obtain that mortgage or not. But it ensures that the buyer knows no one's going to block access to the appraiser or keep me from getting a mortgage when that makes the most sense for me. And whether I get the mortgage or not, I'm promising to close regardless. And then the last very, very minor item you can find on line 333 that simply adds an option for other for additional contract amendments. So that's it. If you've listened to me talk before, this qualifies as a very, very short Matt talk. You're welcome. I hope you agree with me now that the changes both make sense and are mostly in the category of cleanup and clarification items. As always, if you have questions, I'm not the sole person behind this stuff, mind you, but if you have questions, don't hesitate to reach out to me or CCAR leadership so we can ensure that you are equipped as best you possibly can to make the best use of this tool out in the field. Because as I say to people in contract orientation, my life as a practitioner is better when all of you are trained up and operating at your highest and best game. So I look forward to crossing paths with you in the field. And as always, if you have any questions, I look forward to hearing from you.